Question number 76. The offence of cruelty in section 498A of the IPC punishes subjecting a woman to cruelty by the husband or relative of the husband of a woman. This is the correct answer. Any person known to the woman, this is not the correct answer. Any person, not all these, wrong. This is not the right option. Option 1 is the correct option, that is the husband or relative of the husband of a woman. Question number 77. Section 34 of IPC regarding a criminal act done by several persons in furtherance of the common intention of all is a separate offence itself, punishable separately. Option 2, only a rule of evidence and does not create substantive offence. This is the correct answer. Now let us see the question number 78. The Supreme Court upheld the constitutional validity of the offence of defamation under section 499 of the IPC in the case of, here the correct answer is Subramaniam Swamy versus Union of India. Question number 79. A, intending to murder Z by poison, purchases poison and mixes the same with food and delivers it to Z's servants to place it on Z's table. A has committed the offence of attempt to murder. Question number 80. The offence of dowry death under section 304B of IPC is committed where the death of the woman is caused by any burns or bodily injury or occurs otherwise than under the normal circumstances within 7 years of her marriage, and it is shown that soon before her marriage she was subjected to cruelty or harassment by her husband or by a relative of her husband. 10 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband or in connection with any demand for the dowry. Option 3, 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband or in connection with any demand of the dowry. Here in question number 80, the correct answer is option 3. Section 317 of the IPC punishes the offence of exposure and abandonment of child under 12 years by parent or person having care of it. Section 304 of IPC provides for punishment for the offence of culpable homicide not amounting to murder. A, exposes her child with the knowledge that she is thereby likely to cause its death. The child dies in consequence of such exposure. In such circumstances, A may be charged with the convicted of the offence under section 304 of IPC, charged and convicted of the offence under section 317 and 304 of the IPC. Option 3, charged and convicted of the offence under section 317 of the IPC, and option 4, charged and convicted of the offences under section 317 and 304 of the IPC but convicted only for the offence of section 304. Here the correct answer will be option 2, that is charged with and convicted of the offence under section 317 and 304 of the IPC. Question number 82. A intentionally deceives Z into a belief that A has performed A's part of contract made with Z which he has not performed and thereby dishonestly induces Z to pay money. A has committed the offence of cheating under section 415 of the IPC. Question number 83. Section 471 of the IPC states that whoever fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be a forged document or electronic record shall be punished in the same manner as if he had forged such document or electronic record. If a person is convicted only for the offence under section 471 of IPC, he will then be imposed punishment for the offence of forgery of the document in addition to having used the same as genuine. Option 2, be imposed punishment as prescribed for having committed forgery of the document which used as genuine, both 1 and 2 depending on the facts and circumstances of the case, and option 4, none of these. Question number 83, correct answer is option 2, be imposed punishment as prescribed for having committed forgery of the document which he used as genuine. Question number 84, A having insured a ship voluntarily causes the same to be cast away with the intention of causing damage to the underwriters. A has committed the offence of mischief under section 425 of the IPC. Question number 85. Which of the following statement is false with respect to the offence of defamation under section 499 of IPC? It is not defamation to impute anything which is true concerning any person if it be for the public good that the imputation should be made or published. Whether or not it is for the public good is a question of fact. Option 2, it is a defamation to express in good faith any opinion whatever respecting the conduct of a public servant in the discharge of his public functions or respecting his character so far as his character appears in that conduct and no further. Option 3, it is not defamation to express in a good faith any opinion whatever respecting the conduct of any person touching any public question and respecting his character so far as his character appears in that conduct and no further. And option 4, it is not defamation if a person having any authority either conferred by law or arising out of the lawful contact made with the other to pass in good faith any censure on the conduct of that order in matters to which such lawful authority relates. Here the correct answer will be option 2 because in this question it has been asked which of the following statement is false. The second statement is false, which doesn't fall under the section 499 of defamation. A makes an attempt to steal some jewels by breaking open a box and finds after So opening the box, that there is no jewel in it. A is option 1, guilty of no offense as there was no jewels to steal. Option 2, guilty of the offense of attempting to commit theft of the jewels as he has done the act towards the commission of theft. Option 3, guilty of the offense of committing preparation to commit the offense of theft. And option 4, guilty of theft as it is immaterial whether he could succeed or not stealing some jewels. Correct answer is option 2, guilty of the offense of attempting to commit theft of the jewels as he has done act towards the commission of the theft. Question number 87. A begins to unlace the muzzle of a ferocious dog, intending or knowing it too likely that he may thereby cause Z to believe that he is about to cause the dog to attack Z. A has, correct answer is, committed the offense of assault under IPC. Question number 88. The punishment for the offense of forgery of a will is prescribed under section. It is prescribed in section 467 of the IPC. Question number 89. Dishonestly making false claim in court is an offense under section 209 of the IPC. A is cheated with the offense of causing simple hurt. A pleads guilty to the charge before the Metropolitan Magistrate and is accordingly convicted for the said offense and sentenced to imprisonment for 1 year. A can file an appeal. Correct answer is against the extent or legality of the sentence in the Code of Sessions. Question number 91. A is the victim in a gang rape case. At the conclusion of the trial, the accused persons are convicted and sentenced to imprisonment and fine. The court orders the fine amount to be paid to A as compensation. A has also filed an application for the compensation under section 357A of the Code of Criminal Procedure, which is pending consideration before the competent authority. In such a situation, the fine amount cannot be paid to A as compensation since she had already filed an application for the compensation under 357A of CRPC. The state government can pay compensation under section 357A of the CRPC addition to the payment of fine as compensation to A under section 376D of the IPC. This is the correct answer. Option 2 is the correct answer. Statement of a person recorded by a magistrate under section 164 clause 5A subsection A of the Code of Criminal Procedure can be taken as statement in lieu of the examination in chief where the person is a victim in a case. Here the options are punishable for the offense of kidnapping and the victim is mentally disabled. Option 2, punishable for the offense of grievous hurt and the victim is physically disabled. And option 3, punishable for the offense of stalking and the victim is temporarily physically disabled. Option 3 is the right answer. Question number 93. A, knowing that B, C, D, E, F and G are about to commit the offense of dacoity in Kathmandu, Nepal, harbors them in his house in Sitamarhi, Bihar. With the intention of facilitating the commission of such dacoity, A has option 1, not committed any offense as the dacoity was yet to take place, not committed any offense that can be tried in India, committed the offense of harboring dacoits, committed an offense which can be tried and punished only in Nepal. Here the correct answer is option 3, that is committed the offense of harboring dacoits. Question number 94. A, as an employer, deducts his employee's contribution from the wage payable to the employee for credit to the employee's state insurance fund held and administered by the employee's state insurance corporation established under the Employees State Insurance Act 1948. A makes default in payment of such contribution to the said fund violation of the said act. A has option 1, not committed any offense. Option 2, committed the offense of criminal breach of trust. Option 3, committed offense of criminal misappropriation of property. And option 4, committed the offense of theft. The correct answer is option 2, that is committed the offense of criminal breach of trust. Question number 95. Alibi is governed by, correct answer is section 11 of the Indian Evidence Act. Communications without prejudice are protected by, correct answer is section 23 of the Indian Evidence Act. Section 23 of Indian Evidence Act talks about the admission in civil cases when relevant. Question number 97. Under section 27 of the Indian Evidence Act, options are the whole statement is admissible, only the portion of the statement which leads to discovery is admissible, both first and second are admissible, none of the above are admissible. Here the correct answer is option 2, that is only the portion of the statement which leads to discovery is admissible. Section 27 of Indian Evidence Act talks about how much of information received from accused may be proved. Question number 98. A dying declaration to be admissible must be made to a magistrate, doctor, police officer, all of these. Correct answer is option 4, that is all of these. Question number 99. The opinion of an expert is relevant under, options are section 45 of Indian Evidence Act. This is the right option. So the opinion of expert is relevant under section 45 of the Indian Evidence Act. Burden of proof is lightened by, correct answer is presumption, admission, estoppel, all of these.